All right, welcome back. So I understand you have evidence immediately before this across the hall. Okay, good. So there's no excuse for lateness. Same deals last semester. The attendance will be online. I'll usually leave it open for, as you know, a couple minutes before class, then right at 2 I will stop it. So a couple people didn't sign in. Okay, if you didn't get in, just do it now. I think only one person left. Okay. Any questions? Anything in your mind from last week or last class? Anything in your mind? All right, I'm gonna have to close it because I want to do a poll. So I'm gonna end this one now. Sorry, wait as long as I could. If you didn't get it, just email me later. Okay. Okay, so let's do a polling question. Let's see if this actually works. Okay, here we go. All right, so tell me if you see this, if you see it, a poll question popping up now. You see it? Attendance in progress. Oh, yeah. Okay, hold on. Let's try this one. Start poll. There's a new version of the software, so I'm figuring it out. Okay, end session. We are starting your class. Try again. Okay, just don't worry. I'll fix this later. No one's been marked absent today. Don't worry. I'll figure it out. Okay. Oh, I see. Start class. Start poll. Okay. I'm aware. Okay. Well, I'll clean this up later. Don't worry. Okay. Do you see? Okay. Do you see a polling question now? Okay. Good. The Reef has some new software and apparently it's glitchy. I'll figure it out later, but that's less important than the question. All right, so everyone more or less see the question poll now? Okay. So this question will bridge us from last class to this class for adverse possession. The question is this. You have two contiguous lots. Contiguous means they're right next to each other. They're touching each other. And lot number 1 is owned by X, and lot number 2 is owned by Y. Neither of them are in possession. That is, they're not on the land. So then you have a crook named Z. You always have a crook. Z conveys both lots to A. Again, it's a fraudulent transaction. Z has no claim to the land. And it says A enters lot 1 and occupies it in the usual manner for the period required by the statute of limitations. Then A sues X and Y to quiet title. That is saying, who is the correct owner? He's asserting adverse possession. So which of the following are true? A owns lot 1. A owns lot 2. All of the above or none of the above? So just put your answers in there. And Joyce already reminded me that she's next, so you're next. It's okay. We're all friends here. I'll give you another 30 seconds. That cracked. It's all right. All right, another 15 seconds or so to think about it. All right, Joyce, what do you think?
I put A.
That A owns lot 1. That's it.
Yeah.
Okay. Walk me through your thinking. Why'd you put A?
Because it says A entered lot 1 and used it in the usual manner.
Okay.
I figured A only, well, all the elements to adverse possession were only made for lot 1 and not lot 2.
Good. Very good. Okay, that's correct. All right. Joyce, so what did A not do in order to acquire the other lot? What should A have done to acquire lot 2? Enter. Very good. So pay close attention to the wording of these questions. It's not tricky, but you have to pay attention. It says, A enters lot 1. Okay, that starts the clock. Once you enter That's the first element. You have to trigger the clock. A never entered lot 2, therefore the clock never starts to tick. Okay? Everyone with me? Okay. So we have our 4. Yeah.
Would it matter if Z conveyed to A the lots as one singular lot?
Well, when we say 2 lots, that's like Blackacre and Whiteacre. So if they're registered with the county, for example, as separate lots, they're not one. They're separate. Even if they're next to each other, they're contiguous. They're considered separate units.
Yeah.
Make sense?
Yeah, but I was just saying like he conveyed it not as lot.
Oh, I see what you're saying. He said fraudulent. This is all Greenacre, right? The entire thing is Greenacre.
So
Well, you'd have to ask, did he actually step foot on what was in fact lot number 2, right? Let's just say, there's 100 acres. Oh, this is all Greenacre. If he actually walked around both sets of lots, then he would have actually entered both. But here he only entered one of them. Make sense?
kinda, because I know from the last case, what was considered
Mm.
lot 19 was really 3 different lots.
Yeah.
So
The Washington case you're talking about?
the Van.
Yeah. About Valkenburg, yeah.
That, whatever that case is.
I think in that case, the Lutz argued that he actually walked across all 3 of those lots. So it wasn't just, the lot numbers really didn't matter.
Okay.
But here the key point is the word enter. Okay? So let's go over our 4 elements of adverse possession. You have entry. Entry is what starts the clock. You have to have open and notorious. This is a requirement that you put the true owner on notice that he's being squatted on. You have to have continuous for the statutory period. Pay close attention to what jurisdiction you're in. Sometimes it's 5 years, sometimes it's 10 years, and indeed, even within Texas, the number varies depending whether you have color of title. Sidra, remember what color of title means? Yes, what's color of title?
It's the paperwork that you have.
Very good. In Texas and in most jurisdictions, if you have what's called color of title, which basically means paperwork, to show you have some claim to the land, you have a reduced burden. Instead of, say, 5 years, it's going to be 2 or 3 years, right? This case here with this fraudster Z, that would be a case where you have color of title, because you have some paperwork saying, aha, I have a claim to the land, even though the deed was forged. Okay? So those are the first 3 elements. Oh, yeah, Lauren, go ahead.
Well, my question is what if A knew that was an invalid deed?
Oh, he
Does
was
that
in on it.
change that?
So you remember the doctrine of bona fide purchaser? Does that sound familiar? Contracts, you do that? A bona fide purchase for value? Okay, well, so generally, and we'll do this later this semester, but as a general matter, if you know that the document you're getting is a forge and you take it anyway, then I don't think you can rely in good faith on it, right? It's a good faith standard. And if you know that this guy's selling you a junk title, I think it's going to be hard for you to start claiming a color of title.
So we're saying that A owns it because it's a good faith reliance.
Yeah, I mean, the facts of this case is A got defrauded, which is fairly common. Again, I think I said this last semester, but my exams assume that a person selling a piece of land doesn't actually own it, right? Just assume that whoever's selling the land is a fraud, is a crook. Just, maybe you're right, maybe you're wrong, but just start with that assumption, and I think you'll be in a better shape. Okay. The 4th element we talked about is what's called the claim of right. And that generally refers to the state of mind. And we discussed 3 different types. There's the objective standard, where the state of mind's irrelevant. There's the good faith standard, where Lauren, I mentioned a minute ago, you have to say, well, I thought it was mine, but I was mistaken. And then there's the aggressive trespass, or the hostile trespasser. Like, think of Mr. Robinson sitting in the house in Dallas, where it's not mine, but damn, it's going to be mine. And the New Jersey court in the Manila case said, no, we're going to a good faith standard. We don't need to have this aggressive hostile trespasser. All right. So these are the 4 elements of adverse possession. Okay. I want to start new stuff now. It often happens that if you have a 10-year limitation period, the same person isn't squatting there for 10 years straight. Often what will happen is multiple parties will squat together. And this is what's known as tacking, right? Tacking, Tacking, tacking. And tacking allows basically two squatters to combine their time squatting. I don't know how common this is, but the law does permit it. And I have the Texas Code, section 1623. It says to satisfy a limitation period, peaceable and adverse possession does not need to be in the same person, but there must be privity of estate between each holder and his successor. So the first term I want you guys to focus on is this phrase, privity of estate. Jenica, do you remember this term privity? This has come up in a couple of your classes by this point.
Yeah, there's like a contract or some kind of duty of some sort.
Yeah, privity refers to some sort of relationship, right? It can be a contract, it can be an oral contract, it can be some sort of bonds. If you remember in torts, you had privity between people who you could sue, right? That sounds familiar. So Jenica's right. Privity refers to relationship. In order for tacking to occur, you have to have privity between the parties. So I'm going to jump ahead a little bit. If you go to page 101 of the casebook, please. There's some questions. I want to do those first. We'll get to the Kunto case in a minute. But if you go to page 101, okay, and I'll read the first part. It says, and Marcos, you're on deck. It says, in 2000, A enters adversely upon Blackacre, owned by O. Okay? By the way, we have a 10-year limitation period. Just make it easier, everything's 10 years today. So A enters in 2000. In 2007, B comes along. And B tells A, get out of here, I'm taking over. A feels threatened, and he leaves and B enters into possession. Okay, Marcos, 2010 rolls along. Who owns Blackacre?
This is 10 years after.
Right, A entered in 2000. In 2007, B told A to get out of here, and A left. And then 2010 rolls along. So the land was continuously occupied for 10 years, right? Who owns Blackacre in 2010?
Well, my guess would be the guy who came in and took it over.
Which guy? Just use your name. There's A and B.
B.
Was B there for 10 years?
Well, you say he took it over in 2007, then, oh no,
So how long was B there for?
from 2007 to 2010.
So 3 years, right?
Yes.
But what about the first guy, A? Was he there for 7 years?
Yes, it was.
Can you combine those? Go back to the statute, right? Was Texas required to tack together those two periods? What's that magic word?
Well, peaceable and adverse possession was not even between the same person, but there might be privity of the state between each holder.
Is there privity of estate, Marcos, between person A and person B here?
No,
He's right. Why isn't privity of estate?
because the guy just came out of nowhere.
It was hostile, right? It was an aggressive, basically, almost probably an assault probably, but it was an aggressive relationship where B threw A off the property. A and B are not in privity. I said it again. A and B are not in privity. Therefore, you cannot tack together their time. So even though collectively there was 10 years of squatting that met the requirements, you can't add them up together. Everyone okay with that question? All right, Aaron, thank you. You have your name tag?
It's right here.
Oh, I can't see that. Oh, there it is. Thank you so much. No, it was lying down. That's okay. Aaron, let's do question number 2 on the same page, and I'll read it. It says, in 1994, A enters adversely upon Blackacre, owned by O. Okay, so again, A enters in 1994. In 1995, that's the next year, O dies. And he leaves a will that gives Blackacre, you thought you were done with this, right? To B for life, with the remainder to C. Then B dies in 2010. He never entered. What happens here, Aaron?
Is A still on Tacking here?
What does the question say? You tell me.
Then I would assume A would have adverse possession.
Why? What about this will and the fact that B died and the remainder? What about all that other stuff? Does that matter?
I mean, if they're still on the land, they fulfilled all the elements of adverse.
So does it matter that this land was left in the will for the B and for C? Does that even matter?
Not really.
She's right. She's exactly correct. So long as the squatting's going on, there's a duty of the owner to eject. If the owner is O, he has a duty to eject. If the owner becomes B, B has a duty to eject. And indeed, if C is the remainderman, C has a duty to eject because he knows if B doesn't get his act together, I lose out on my future interest. So actually, C, as the remainderman, can take an action to eject A. But that didn't happen here. So he was there for, 16 years at this point? A was there for 16 years. He met the limitation period. That's it. They're done. So the land belongs to A. He acquired it at some point in 2004, if my math is right, well before B even died. Yeah, Mike?
So is that almost the owner's equivalent of tacking?
I know what you're saying, but just say it one more time so everyone else understands it.
Does that end up being almost the equivalent for the owner's responsibility in regards to tacking?
Yeah, don't use the word tacking, but you see what Mike's saying, right? There were 3 different people who could have objected, right? O, B, and C. Each of those 3 people had the opportunity to object to the squatter, and none of them did it. And because they all screwed up, they didn't exercise their rights, too bad, right? And I think the book describes it this way: if the owner can't exercise his rights, then the courts won't do it for him. Right? If the owner can't get off his butt and kick out the squatter for 15 years, whatever it was, 10 years, then the courts are of no help. So this is like an easy question, but it's complicated a bit because there are 3 different owners. But I think Mike is on the right track. They all had the chance to eject. They didn't. Too bad. They lost Blackacre. All right. Any questions on that? Not too hard, but just pay attention to the world the moving parts are. Okay. All right, Andrew. You want to give us the facts in and I'll help out with this one. The facts in this case are a nightmare, but at least just start us off with Howard versus Punto, please. It's a mess.
There was an original owner of a lot. He built his property, his house on it, whatnot. However, the deed described the lot next to him. And then, as we later found out, this was a problem with the whole neighborhood.
Yeah.
So like, even though I'm sitting, I think I got this as, even though I'm sitting here, my assigned seat's there. Even though Aaron's sitting
Perfect.
there, her assigned seat's there.
That's, yeah, exactly
Okay.
right. Yeah.
No, I'm not as confused. And so this went over time. He still had his house on that lot. He eventually sold it to Punto,
Good.
who used it as like a vacation home
Good.
or a summer home.
Good.
And eventually another gentleman came along who figured out the error and tried to, I guess, do some deed swaps and fix it.
Didn't work
But
out.
Punto said no.
Yeah. Yeah.
And that led to the issues that the court was trying to decide. Is one is just using a home just as a summer home. Is that a manner that uninterrupted use? And then that they also addressed the issue of tacking.
Very good. Perfect summary. The facts of this case are like a property nightmare, right? Where no one is on the right spot. And has anyone ever been to the Hood Canal in Washington? I had a student from there a few years ago. It's beautiful. It's a gorgeous place, but just take a look at the coast. It's very jagged, right? And it's very winding. And you can imagine how if you're conducting surveys, it's not always clear where the borders are. And why? Water moves soil, right? When you have this body of water, it's a channel basically, cutting through the land, you have land that's called accretion and avulsion. Ah, great words. Did I mention these last year? I can't remember. Accretion and avulsion. If you know these, I think it's 2 C's. Accretion is when you have a slow and gradual changing of borders because of water, right? Where water dumps some soil and it moves some soil, right? It's a slow process. So over the course of a decade, maybe your property line might move over an inch or two. That's called accretion. And generally, when you have accretion, you have to conduct new surveys to reflect the fact that soil's moved here and there. Okay, that's accretion, slow. Then you have something called avulsion. That is where you have Hurricane Harvey, right? Hurricane Ike. These massive storms that dump a lot of soil near the water, and it shifts all the boundaries. So think of like after the last hurricane in Galveston, you have all this new sand that shows up, right? When you have new sand, you actually have new land to account for. And it's actually a very complicated fact. So when you have avulsion, there's a lot of litigation for who owns it. Is it owned by the state? Is it owned by the property owner? And in Texas law, it's usually owned by the property owner, which is, I think, the correct ruling. But you can imagine just thinking about these borders, how tough it is to keep track. In this case, they screwed up royally. Okay, now, Andrew mentioned the 2 issues. I want to do the first issue first because it's a lot easier, right? So, Miranda, does it matter that this summer home was only used for a couple months out of the year? Does that defeat the continuous requirement of adverse possession?
This court says no, but the top court said yes.
Yeah, why the the Supreme Court, I'm sorry, reversed that decision?
Well, they said because it's a summer home and it had been previously used as a
Good.
summer home, and if that's the normal use of the land, so
Good.
it makes sense to say, well, you didn't want to do that.
Yeah, exactly. That part's easy, and I don't know why the trial court made such a mistake. I mean, that's we did this property first day of class, right? It's not required to be there 12 months out of the year. The rule is that you have to use it in the same fashion as the record owner would use it. And if this is a summer home and you're there for a couple months of the year for the summer, then that's it. You don't have to be there 12 months of the year. The law never requires us. That part's easy. Right? We can dispose of any questions in that part, the continuous part. The harder element is actually, I guess, is a combination of entry and open and notorious. So they sort of blend together. No one entered the lot they thought they were entering. Right? And let me show you this picture. The picture in your book is this black one. I think it's a little tough to read. I like this picture a little bit better, which I found on the authors have a supplemental page. Everything was one lot over. And let me see if I can explain this to you without making my head spin. Right? So there were 3 lots. 1, 2, and 3, or A, B, and C. There was no house on this lot. It was empty. There was a house on this lot and a house on this lot. This was the lot in Howard's deed, right? This was Howard's lot, but this was Moyer's house. So Moyer and Howard said, I have an idea. Moyer said, you have your house there. Howard gave Moyer the lot where his house is on. Let's say it again. This is Moyer's house. After the swap, everything was fine. Moyer's house was on Moyer's lot. Okay, great. But the problem is, the lot that Howard got had the Kunto house on it. What do you do there? Moyer, and then by Howard, by extension, said, this is my lot. Kunto said, no, my house is here, and I've been here long enough. So I think Andrew said they couldn't work it out. There's a good reason why they couldn't work it out, because Kunto's house was on someone else's lot. Now, wouldn't it have just been really easy for everyone just to move one lot over and just sell the lot to the land of their neighbor? But the problem is, Kunto owned this lot, right? And he couldn't move his house over. So there was one transaction too many that wouldn't work, right? It's like everyone was in line. You can get everyone in the back of the line, but the first person in line you can't work out. Okay. So you have this deal. So Kunto claims that he was there for, I think, about a year. but then his predecessor was there for, more than enough number of years for the limitation period. So the tacking here isn't that complicated. Why I think this case gets a lot more complicated is, what is the correct state of mind, right? No one on this block thought they were squatting. This is not like Mr. Robinson, right? This is actually similar to the stairs, the New Jersey case with the stairs that went a few inches over the boundary, right? Everyone thought it was fine until you had the survey done. So Madison, this is going to take a few questions, but let's start here. How does the court go about thinking of what the heck is going on with this neighborhood? It's so messy. How does the court do this?
Well, I think they decided because they were all in the same belief that they were living on what they thought was their own deed and land,
Yeah.
that established, because they shared that belief, that established.
Right. Oh, and by the way, almost everyone got the question right, which is very good. I forgot to run the poll, so good job, everyone. Unless people change it, which I can't help. Oh, that's right. People change it, don't they? People. All right. But yeah, Madison's correct. So the first idea is, well, generally, privity is not meant to be the sort of stringent requirement. It's meant to be sort of flexible, and it should adapt to how people engage in property transactions. And the case here wasn't that you had, these hostile trespassers. These were people in good faith living in their homes who were simply mistaken. So the court finds that you could tack together the period between Kunto and his predecessor in interest. So that wasn't the harder part, right? The harder part, Cheyenne, what's the claim of right? What's the state of mind that the court imposes here to resolve the adverse possession claim? What's the correct state of mind?
Something to do with like their, like claiming more land?
Well, was anyone claiming more land than they already had?
No,
What were they claiming?
like
Different. Yeah. So it wasn't the case like with the stairs where you say, yep, this is mine plus 15 inches, right? The stairs went over. They were saying we're claiming a completely different set of land. But Cheyenne, what state of mind does the court impose? What's the state of mind requirement that the court imposes here? We discussed a couple of them last class.
So,
Do they require, I'm sorry?
the good faith.
Good faith, thank you. Yeah. So the court says that the requirements of privity should not upset long periods of occupancy when you have a person who in good faith received an erroneous deed. And this is Lauren's question to me a few minutes ago, right? When you receive a deed that you think is good, and then you rely on it in good faith, the courts will generally help you out. And that was the case here. Kunto got a deed. He relied on good faith. Even though he didn't have any intent to squat, he didn't even know he was squatting, they basically waive it. So this is another case where when you apply a good faith standard, the fourth element of adverse possession basically vanishes, right? We discussed there are four elements. When you give a good faith standard, your claim of right doesn't really matter. All that matters is you get the entry and you have the requisite period, and you do so openly. Everyone see that. Now, Megan, a related question for you. Was the squatting open and notorious if no one knew what the correct boundaries were? How can that be notorious if no one knew what their boundaries were until the survey was performed years later?
Everybody knows that they're living there.
Right, but they know that they're squatting there. That's the key question. Did anyone know anyone was squatting?
No.
So how was the open and notorious element satisfied here, Megan?
Because of the trespass?
But no one knew until this. In other words, for all the decades of living there, people thought everything's fine. But then when this new survey was performed, that's when the error arose. How does the court address the open and notorious requirement here?
I know they talked about it being
unreasonable to survey it every time.
Yeah, I think that's in the right direction. Basically, the court says, well, it's true, this wasn't actually open and notorious because no one knew about it, but because of the geography, because of the way the water cuts, we can't expect people to do this. So in other words, I mean, just think about this, right? Out of the 4 elements for adverse possession, basically entry and the continuous are the only ones that really mattered here, right? They kind of said, oh, forget about number 4 and number 2, whatever, right? This is one of these weird cases where the doctrine sort of falls apart. So the court finds here that Kunto was able to tack with his predecessor. He entered, and you count the number of years, and that's it. The state of mind doesn't really matter. It was good faith. And even though no one knew he was squatting, right, it doesn't matter, right? So it's a weird case, and I think it notes, the notes afterwards say that this case was sort of reversed by statute, where the people of Washington amended it, the legislature, saying that good faith by itself is not adequate. All right, which I think, we can argue about that, but this decision, does it seem fair? I don't know. Casey, what do you think about this decision? Does this seem like the right thing to do? I mean, basically, Kunto made out okay, but Howard got screwed. So you think Howard was playing a little fast and loose here? You think that's why the court didn't reward him? Just explain a little bit more. I think you're on the right track, just so everyone understands your point.
So he switched lanes with the lawyer.
Yeah.
And he thought he was gonna get the Kunto property because it had a house on it.
Oh.
The lawyer never really owned.
Yeah. And let me just make an amendment to Casey's point, which is correct. He didn't just want the Kunto property, the land. He wanted the house. So maybe that's it, right? Maybe Howard was trying to get double dipping, right? He would get this land from this other guy next door, and he would get the land plus the house. And then Kunto would be homeless. I mean, he could have just been not so selfish that, all right, I have my land, I can just move on with it, right? He didn't need this extra plot. This is a case where it becomes very clear, when you buy Blackacre, you're not only buying Blackacre, you're buying the house on top of Blackacre, right? Everyone understand that point? Yeah, but I think Casey makes a fair point. Anyone else want to add anything on this case? Any thoughts? Weird case, very complicated facts, very messy. Yeah, Christiana?
Did they get, so the Kunto property, did they get both the property without the house and the house property?
Look. So I mentioned there was an empty lot there. So they keep their empty lot, and they acquire this through adverse possession. So basically, Kunto made that pretty good.
Right.
I mean, they keep their house, they gain one lot by adverse possession, and they sell the one next door. Now, I mean, the smart thing to have done, I suppose, would have been just to give Howard this lot and swapped, right? Wouldn't that have just been avoiding litigation? Kunto said, you know what, don't sue me. I have this empty lot next door, I'll give it to you. But Kunto said, I'm going to court, and then he won. It's a risk, though, because it could have gone the other way, and if Kunto lost his house, then he'd be homeless. So, it's like a negotiation tactic. You have a chance of gaining 2 lots, or you wind up with 0. There's no in between. Which one do you choose? Which one do you choose?
Well, if I was Kunto, I would go to litigation, obviously.
Yeah, but the doctrine wasn't clear at the outset. I mean, we know in hindsight the guy won. But what if the court said a good faith standard is not enough? Because
Honestly, I'd probably try to settle it before we went to court, so we don't have to deal with attorney's fees. But
yeah. That, by the way, you guys get paid for attorney's fees. That's how you pay your bills. But yeah, but no, I think Christiana's right about this, right? It's a risk when you go to litigation. But if I was a lawyer, I would say, look, the court's not going to screw up the entire block, right? Because the court ruled against Kunto, the entire community would basically illegal, right? Everyone would be on the wrong lot, and it's very unlikely the court would do that, so it disrupts a lot of people who don't even know what's going on. So this, I think, was the least disruptive thing they could have done, right? This is probably the least disruptive thing they could have done to resolve this entire community's problem, I think. All right. Anything else in this first case? Kunto? Yeah, Maria?
Does it matter if everyone is off because of gentrifying?
What do you mean?
Where the city goes in and changes where everything is and everyone's survey ends up being off a little bit?
What do you mean the city changes? I'm not sure what you mean.
So, we are working on cases somewhere where there is a place in the case that has done city messed up the survey. And because of that, everyone is a little like their kitchen, everyone, cause like cookie
A
cutter.
couple inches over and stuff.
Everyone's kitchen is in the other person's property.
Everyone in the entire block.
Uh-huh.
Is this a case you're working on now?
I'm not working on it.
Do you know what happened?
I have no idea. I don't even know what's going through yet.
Well, so we'll do a case later this semester where a property owner buys something and he gives a deed to record to the county official, and either the county official doesn't record it on time or forgets to record it, or even worse, records under the wrong name. He just makes a typo on the computer. And as a general matter, you can't sue the government when they screw up like that. My inclination is adverse possession would probably resolve it. How long has those errors been going on for?
A long time. I think that the person who came in because the neighbor wanted to sue her. She was like, my family's almost property for like 60 years.
Well, in one of their addendum, Texas has the hostile state of mind requirement, and I don't think the New Jersey, the staircase case, I don't think that would work in Texas. So I think they should probably work out some settlement. I think. I guess. Any other questions on the first case? Okay. So I think that that resolves the first case. Okay. The next case, or the next topic I want to talk about, is disabilities. Okay. We already did the tacking questions. The next topic we'll talk about is disabilities. So this is a doctrine that's not limited to adverse possession. You learn this in contracts when you have an age of capacity, right? If you make a contract with a person under the age of 18, as a general matter, the contract is not going to be enforced, because we say a person under the age of 18 is not it lacks capacity. Okay. Now, why? It's actually a statute in Texas, I think all states, that says a person is under a legal disability. It doesn't mean he's disabled, that he's a handicap or he can't get around or whatever. It's a legal disability. If a person is younger than the age of 18, regardless of whether the person is married. So if you make a contract with someone under the age of 18, it's not effective. But the same doctrine applies not only for making contracts, but when you have limitation periods. Right? So if you try to squat against a person under the age of 18, the clock doesn't start ticking. The clock only starts ticking when the person turns 18. And, God willing, everyone who's 15 in 3 years becomes 18. Now, people might die, but eventually a person with an age under the 18, if they keep living, will get to 18. And you start ticking the clock when they turn 18. Okay, that's an easier disability to deal with, because everyone ages out of adolescence. The second one's a little bit tougher, unsound mind. The statute doesn't define that, and I don't need to go too far into details. I'll just say this person's not of sound mind. I'll leave it there. I don't want to get into the nuance of what that actually means. But it's possible a person can be of sound mind today and can be committed tomorrow, deemed unsound mind. And at some point in the future, he says, okay, I'm sound mind again. So unlike age, you can fall in and out of unsound mind for disability. You can fall in and out of it. Okay? Why is this important for disability? You only have one question. Is the disability present when the squatting begins? If a disability arises after the squatting begins, it doesn't count. So let's say I start squatting against someone in 2000, and in 2001 the person falls into a coma. Doesn't matter. Because there was no disability at the outset, doesn't matter, it makes no difference. The thinking is he had a 1 year, he could have kicked me out and did it. Now, if, say, you squat against someone who is, say, 14 years old, the clock doesn't start till they're 18, and that's when the 10-year clock starts. One other rule. You can't tack together multiple disabilities. So let's say you start squatting against a 14-year-old, and then on his 18th birthday, he gets into a car crash and gains a mental disability. Doesn't matter. You get one disability, you can't tack them one to the next. Okay? Texas only offers 2 grounds for disability: age and unsound mind. Other states have modifications. Like some states say if you're incarcerated, if you're in prison, a limitation period can't run against you, which makes some sense. If you're in jail, you can't really eject someone. Some states say if you're deployed overseas, the limitation period does not apply to you. Texas is only these 2 that I'm aware of, but other states have a much wider range. Yeah, Mike.
Is the soldiers and sailors? I forget the
Soldiers and Sailors Act. Yeah.
With that being federal, isn't that one of the protections in?
Yeah, the Sailors and Soldiers Act, which I don't think is constitutional, but leave that aside, says that you can't sue certain members of the military while they're deployed. It basically puts a hold on statute of limitations. This was actually used against President Kennedy because it was an argument that he was like a reservist, which was bogus anyway. Yeah, Kendra.
Doesn't the statute not start until they find out about it anyways?
I'm sorry?
Like if a soldier's overseas, doesn't it not start running until they find out?
Having an open and notorious requirement when you're overseas is probably tough, but you could imagine someone sends them a message like, hey, I'm squatting in your land, start the clock. So it could happen. You can do it. You can say, text them, I'm squatting, you have the picture, you take a selfie in the land, right? It works. So let's do a couple of the questions about disability. Go to page 102, please. And let's do these questions. Who's next? I'm to it. Christiana, you next?
Yes.
Ask a question, doesn't skip. Yeah, you remember the drill. All right, so here's the facts. Okay. O is the owner in 1995, and A enters adversely on May 1st, 95. We know the age of majority is 18. That's the same in every state. Okay. O is insane in 1995. O dies insane and intestate in 2008. So just stop right there, Christiana. Was a disability present when the squatting began?
Yes.
Okay. And did that disability ever vanish?
No.
So when would the clock start ticking in this first question?
The person dies.
In 2008. And given a 10-year limitation period, when does it run out?
2018.
Very good. So we know from the first question, because the person had a mental unsound mind, I'll just leave it there, you count 10 years from 2018. Okay? I'm sorry, 10 years from 2008, which is 2018. Okay. So now, Elena, the next part says, O's heir, H, is under no disability in 2008. Does that matter about when you start counting 10 years?
I guess it started from 2008.
Right. Does it matter? Does H's disability matter in 2008? No. Very good. So it's still 2018. Elena, let's do the part B. What if the heir H is only 6 years old in 2008? Does that change the clock?
I guess it does.
Why?
No, it will not.
Good.
It's only you married.
Good.
Yeah, right.
How many disabilities can you put together? Uno. You get one bite at the apple. So you have the disability of O, that's it. It makes no difference if H is 6 years old in 2008. Doesn't matter. So the answer again is 2018. That's when the statute runs. Everyone okay with that one? Okay. All right, Hannah, let's do number 2. I'll read it. It says, O has no disability in 95. Okay. O dies intestate, that is without a will, in 2004. Okay. So at that point, Hannah, he's been squatting for how many years? From 95 to 2004? 9 years. Not there yet. He almost got there, right? But at the time when O dies intestate, the heir, H, is 2 years old. What happens to the clock once it's inherited by H, Hannah? I'm sorry?
It doesn't stop.
What do you mean it doesn't stop?
So it keeps, so I mean, you would acquire it in 2005.
So, the statute runs right? Because when did the disability arise?
After the clock started.
Very good. If a disability arises after the clock starts ticking, it's disregarded. Everyone understand that, right? When disability arises after the clock starts ticking, doesn't matter. So because O was of sound mind in 1995, the statute runs in 2005. No problem. Okay? Everyone okay with that one? All right, Lisa, let's do the third one. I'll read it. It's a little bit more involved. O is 8 years old in 1995. Okay, let's just start right there. Is there a disability, at least, at the start of the squatting?
Yeah. Oh, wait, no.
Well, no, it says O is 8 years old in 1995. That's when the squatting begins. Is there a disability present at that time?
No.
Why not? What do I mean? When I'm asking, is there a disability present? What am I asking you?
Oh, he's too young. He's not 18.
So let me ask you again. In 1995, when the squatting begins, O is 8 years old. Is there a disability present when the clock starts ticking?
Yes.
Okay. So how long then, Elise, does that disability run for? He's 8 years old, right?
So 10 years.
Okay, very good. So he's 8 years old. The clock will not start ticking till 2005, when he turns 18. And then, Elise, how much longer does the squatter stay in the land after 2005?
2015.
Exactly. You count 10 years from when the disability expires. Again, I know you hate math. Just follow me, right? He's 8 years old in 1995. He'll be 15 years old in 2005. That's when the clock starts. And you go 10 years from 2005 of squatting is 2015. Okay? The rest of the stuff, well, let me ask you, is James, right? Does it matter that O becomes mentally ill in 2002, then he dies untested and all this other stuff? Does any of that matter? Bingo. It's irrelevant that O became mentally ill when he was, 15 or 16 years old, right? Irrelevant. You get one disability, you can't tack him. You get one disability. So in 2015, then the squatter prevails. All right, questions on this? Yeah, Lauren?
So, in terms of number 3,
Mm-hmm.
it, because the disability was already there,
Good.
in those situations when the disability is already there, when the clock starts ticking,
Mm-hmm.
we count the 10 years from when the disability expires.
Exactly.
But if the disability is not there,
That's it. Doesn't matter.
then it doesn't.
That was question number 2, right? If the disability is not present at the outset, you don't tack. You don't. The clock ticks the entire time.
Okay.
Okay. Anyone with me? Everyone with me? Okay. There's a brief discussion of adverse possession against the government. I think I mentioned this last time briefly. At common law, you couldn't squat against the king. And many state courts have said that the state owns certain lands for the trustful people. You can't do it. But in some jurisdictions, you can actually acquire adverse possession from the government. But the flip side of this is the government can get adverse possession from you. So it's even possible the government squats in your land and the government gets it. Fair? I don't know. But this doesn't come up very much. It's fairly rare as far as I can tell. All right. Any other questions on that? Not very important. All right. Any people actually like art? You know, and actually knew who George O'Keeffe was before this case? Yeah? I don't get art. I don't. It just doesn't do anything for me. I think I said the same thing with remember the case of the painting and the guy, the son got the painting. I don't get how people spend money on art. I don't understand it. Whatever, not my thing. And especially this art. It's, I don't believe it's your imaginations. Okay. Bless your heart. All right. Brandy. Okay, there you go. So Brandy, yeah, I'm not going to ask what you see. It doesn't really matter. Let's look at chattels, okay? So you can not only adversely possess real property, you can also adversely possess personal property. When I say personal property, I mean chattels, stuff that can move around. Think of like, the Fox case, right? Pierce v. Post. It wasn't real property, it was a chattel. It was a personal property, it's a piece of, fur, whatever it was, right? So Brandon, let me ask you this question, right? Can a thief, right? I go to your car and I steal, a phone from your car. You know that I stole it and I have it for 10 years. And you did nothing to try and get it back. Whose phone is that? Yeah. Isn't that weird? Right? Now, the police perhaps could arrest me, although usually there's a statute of limitation for criminal, right? 2 or 5 years. So, in theory, it's possible that you can steal a person's personal property. They never call the cops. They know about it. They take no action. And you actually acquire title to it. Messed up, right? Weird. But the law says if Brandy knew my phone was stolen and she did nothing to recover it, then that's it. So that's a case we're dealing with here. Now, Brandy, you want to try and walk us through the facts here? The facts here are not quite as messy as the first case, but pretty close.
Yeah.
And by the way, this is again the New Jersey Supreme Court. What is New Jersey going to do? Reverse the Commonwealth. I swear, it's every single time it's the same thing. I don't need to read the case. All right, go ahead, Brandy, please.
Okay, so Margaret O'Keefe is the painter.
Good, that's her.
And she has 3 paintings that she claims are missing or went stolen.
Yeah.
Snyder has one of the paintings now.
Good.
And he said that he bought it from Frank. And Frank got it from his father.
Or so they say.
So they say.
Yeah.
But the dates of when she claims the paintings went missing does not add up with the date that Dr. Frank had the paintings.
Good. Good. Very good. Okay, I'll let you go there. It's worse than this, right? So, I mentioned last class that one of the reasons why you have a limitation period for adverse possession is that memories fade, records disappear, right? Evidence just vanishes. This case illustrates that principle very clearly. So we're talking about photographs that were stolen in the 1940s, and they were found, I put the scare quotes up, found in the 1970s. So we're talking 30 years past. Now, I couldn't tell you what I had for lunch yesterday, right? I don't know. Can you imagine trying to think back where this painting was 30 years ago? I mean, it's a very hard thing to do. And this case illustrates why you have a limitation period of a fixed duration, 5 years, 6 years, 10 years, whatever. To prevent this sort of he said, she said, where no one knows how the paintings wound up in this guy's house. Just no one actually can trace it because memories are gone. People are dead. This woman was in her 70s by the time this happened. So, no one, or sorry, 80s even, I'm sorry. No one really even knows. But let's just put the facts aside for now, right? Mary, so you're an appellate court, right? You're a law clerk from the New Jersey Supreme Court. And you get this case before you. And none of the facts are clear. What do you do as an appellate judge if the record is unclear?
Tell them to go clear it up.
Yeah. Send it back to the trial court for trial, right? You guys know this from CivPro. You can't grant summary judgment or equivalent based with disputed facts, right? You have to have undisputed facts. If the facts are in dispute, you go to a trial. So, again, this is Jersey. This entire opinion should have been one sentence. Because the facts are unclear, we remand for further proceedings. Right? Hell of a lot easier for you to read, one sentence. Maybe 2. We find the facts unclear, period, therefore we remand for further proceedings. But of course this is New Jersey, and they want to make social policy, and that's what they do there. So you have to read this entire thing. So let's just start off with the basic rule before Jersey got to it. So Rochelle, as a general matter, before Jersey mixed things up, how would you calculate or how would you determine the statute of limitation for this case? Just as a general matter, forgetting all the stuff Jersey did. 6 years from when? That's right. The limitation is 6 years. You're exactly right. But 6 years from when? That's the question I want to. That seems really low. I'm going to bang my head at one point this year. 6 years from when? Okay. Now here comes the follow-up, Rochelle. Is this when the paintings disappeared? When Miss O'Keefe knew they were missing? When she found out that they were hanging in a gallery somewhere? 6 years from when?
I guess like what a reasonable person would do.
Oh, I like your answer better than what the court did. Yeah, I think her answer is correct. But the difficulty here is that Mrs. O'Keefe was, this rising artist, and I'm sure she was very busy. And apparently, she never called the cops, and she never reported it stolen. And there's some evidence that she didn't want to upset her husband, whatever. We don't really know. So, Brooke, did Miss O'Keefe exercise any sort of due diligence in the 1940s to reclaim these paintings?
In the 40s, I'm trying to see when she notified the Association of America.
Did that happen in the 40s?
I don't think so.
Yeah, when it happened?
Until 20 years later.
Yeah, basically the 70s at that point. So my question to you, Brooke, did O'Keefe actually exercise any sort of diligence when she was aware the paintings were missing? Okay. So that, I think, makes the equities cut against her, right? She knew the paintings were missing, and she took no action whatsoever to recover them. Maybe she had reasons. Maybe she didn't care. Maybe they weren't valuable. Maybe her husband had a thing. I don't know. It's actually a sad story. Her husband was a photographer, and he basically left his wife for the women he would photograph nude. I mean, there was a lot of stuff going on here. So she had other stuff on her plate, right? It's just Google her. Very, very tragic figure. Artists usually are, which is why I'm not artistic. Cause I don't get art. It's just weird. Anyway, don't go to a museum with me. It's not very fun. The gift shops are good, but she did not exercise any sort of due diligence. So, under the traditional rule, she was out of luck. She knew the paintings were missing in the 1940s, whatever year it was, 1940s-ish. However you count 6 years, you don't get to adverse possession. In that case, the person who has it in their study, in their gallery, would be able to tack on the time of his predecessor, and they get to adverse possession, and they're his. Right? But, again, we're in New Jersey, and New Jersey courts do different things. So, Reed, what does the Jersey court do here? What test do they put forward to resolve this issue?
They jump into
The discovery rule. What is, Reed, tell me, what's the discovery rule?
So the book says it is a cause of action that will not accrue until the injured party discovers, or basically should have discovered the facts.
Ah. It's a rule that says the clock doesn't start until the person discovers or should have discovered the property is missing. Now, again, she knew the property was gone, right? She knew it was gone. So, Reed, just one more. How does this discovery help her at all?
Because if she could say, like, hey, I've been trying to find out where it is, but I didn't exactly know
Oh,
where
I
it is,
see.
using her due diligence to try to find out, then that could be beneficial.
I see, right. So what Reed says is, well, even if she knew it was missing, she was still looking around for it. Was she actually looking for it, Reed? Doesn't seem like it. Again, so this entire case is a dictum, right? The entire case is I don't know why it exists. I struggle with this case every year when I have to teach it. It's just it doesn't matter because the facts are so obvious that she didn't do her due diligence. But they put forward this discovery test, right? Now, Ryan, why do they impose this different standard for personal property, right? The rule for real property remains the same. But why are they putting this other standard for personal property? It can move around. it can be hidden, right? Imagine if it wasn't art. Imagine if it was jewelry. A person can keep their jewelry inside a drawer and no one would ever see it. The only reason why this case arose was because it was on display somewhere in a gallery. People like seeing art publicly. So the discovery rule is meant only for a personal property, that is property that can be moved around. Why? Having stolen property, it's usually not displayed openly and notoriously. But the discovery rule is also a little bit different with respect to the burden. Right, Jake? What do you mean by the burden? What does that mean, the burden of proof? You know about this from Bryce Civ Pro.
You have to prove that you were actively.
So generally in adverse possession, who has the burden? The person who owns the property or the squatter?
The person.
Oh? So if Mr. Robinson is squatting, the burden's not on him?
Oh, yeah. The other person's trying to obtain.
Yeah.
property.
Generally, the 4 elements of adverse possession must be satisfied by the squatter. He has to show when he entered. He has to show that his entry was open and notorious. The squatter has to show that he was there for the requisite number of years. And the squatter has to show what his state of mind is. But here the court flips it, right? Here, the burden is not on the squatter, the guy having the art gallery. It's on the original owner, O'Keefe, the artist. Right? She has to show, right? She has to show that she exercised the requisite diligence in searching for it. So this flips the entirety of adverse possession on its head. You want to see that, right? Usually it's the squatter who has the burden, but here it's the original property owner who has the burden. And they go one step further. This one always makes me laugh. They say, we also suggest that they should make like a database or something, like some sort of record-keeping system that people can find lost art. Who the heck are they to make these recommendations? It's a Jersey thing. You wouldn't understand. I'm from Staten Island, so it makes sense. So, anyway, so the bottom line is, for real property, the rule's the same. But for personal property, that is chattels, they put this discovery rule. And the clock only starts ticking when you knew or should have known the item was missing. And the burden then is on the owner to show that they exercised due diligence. Again, I don't see how O'Keefe can possibly win in this case. She did no diligence. She knew it was missing in the 40s. And indeed, the book has a little discussion of what happened afterwards. They settled, right? It was like in Kendra. They settled the case. O'Keefe had 1 painting. Stoddard took the 3rd. And they sold the 3rd one at Sotheby's. Why? To pay for legal fees. Right? Lawyers always get paid. Yes, Kendra.
Is due diligence how a reasonable person would do it, or how the people in the field, like the art field here, would do it?
That's a good question. I think it'd have to be based on what the peer review posts, right? What the people in that industry would usually be accustomed to searching for. Because, what would I know as a reasonable person? I'm not reasonable, but you as a reasonable person to find stolen art. Da Vinci Code, right? I have no idea. But I suppose that if you're an art hunter, you know to look at certain things. This is actually a huge thing. Professor Fincham, if you had him, knows a lot about antiquity and art. That's his specialty. There was a story a week or 2 ago where there was a librarian at the University of Pittsburgh who managed their rare books room. And over the course of a decade, he was stealing rare books and just selling them on the black market for like hundreds of thousands. And it's not just he stole books, he would cut out pages from rare books, and just sell 1 page at a time. And there was a dealer in Pittsburgh who apparently he didn't ask any questions, or maybe he probably knew, and he would just sell stuff and people say, oh, we don't have to ask any questions. So if you buy, I've actually bought some rare books on eBay. They're not that expensive, but you have to be a little careful because you don't know where they come from. And this guy was selling these one-off books that were hundreds of years old. So this is a legitimate marketplace, and because it's so old, there's no way of tracking it. This guy's going to jail. I don't know why he did it. He didn't make that much money. He made like $100,000. I mean, it's not, to spend the rest of your life in jail, you should spend. You need more money to get. You should have asked for more. Yeah. All right. So any questions on that? Any questions on that? Don't think about stealing books. We have a rare book room here in South Texas. It's very nice if you want to. The librarians will show if you ever actually go to the library. Yeah, exactly. All right, so let me summarize a bit, and I'll let you guys out early because it's a fairly quick class. You have to remember your 4 elements of adverse possession: entry, open and notorious, continuous, and claim of right. With respect to tacking, you can have two people satisfy the period for the continuity, but they have to have privity. It's interrelationship. Also, with disabilities, keep in mind that the disability must exist at the outset of the tolling period. If the disability arises later, it doesn't count, and you can't tack together 2 different disabilities. I think that's it. Any questions? I will see you all on Monday. Thank you very much.